Following the judgment of the presidential petition, lawyers drawn from the Azimio camp and the Kenya Kwanza camp took the opportunity to give their varied opinions. Azimio side insisting through its lawyers that whereas they respect the court's decision, they do not agree with it.
We accept the decision, but we do not agree with it. And I'm saying this as a seasoned practitioner that courts sometimes make mistakes which have to be corrected over time. Courts make political decisions.
But why are they disputing the 7-judge bench judgment?
Camargo's name was not supposed to be on Form 34A. If at all he was involved in this election, he was involved on the technology side. So to find it anywhere near a Form 34A raised more questions than answers. There was silence.
If you read any legal material on what should be a turnout, including the Black's Law Dictionary, turnout is normally based on the registered members in a country as against those who turn out to vote. So there are so many other examples we can take up.
Their complaints further touch on IEBC servers question, which they say were never opened.
The servers were not opened. The involvement of the Venezuelans for a full month before, half a month before the elections and up to the 16th of August was not explained. No, it wasn't even offered. We perhaps are a little distressed on the over-reliance of a registrar's report that has no input from us.
Although time was of the essence, but I think we had sufficient time to carry out a proper audit.
With regards to court's claims of perjury undertaken by its lawyers.
Forgeries, when the DCI, the Director of Criminal Investigations, what do we put before the court? A lot of it was from an agency of government. I didn't see them talking about similar incidents in matters concerning the Independent Electoral and Boundaries Commission. That's why I was saying it was a little ideological. They were looking for things on which to destroy our case, but similarly not taking sufficient time to look at what happened on the other side. And that will be another story for another day. Somebody I really respect as an advocate, Julie Soweto, it was described as hot hair, but you could see when that evidence was being adduced before the court, how engaged even the justices were. So I found it rather odd for them to describe it as hot air.
But the respondent side, drawn from the Kenya Kwanza, are asserting that the court's decision is a vindication of their clear win.
They have done these proceedings in a very excellent, ethical and professional manner. The lawyers have conducted themselves very well, and we know that the democracy space in Kenya is growing, and together as a nation we can develop, together as a nation we can concentrate on the issues that are affecting mwananchi.
The Kenya Kwanza team insisting that the court has set a judicial precedence. However, they had a few words for their counterparts.
IEBC is maturing, the challenges we have experienced notwithstanding, our judiciary has just demonstrated that their maturity is also something to be celebrated.
Kenya Kwanza are arguing that the verdict now sets the stage to fulfill the promises they made while campaigning.
It's one thing to have allegations in court, you know. Don't over-dramatize things. Don't draft an election petition like you're doing a book of science fiction. Do it like a lawyer. Do it, plead what you know it is right. And it is just and it is well-founded in you.
The verdict is out, and the Supreme Court decision to uphold William Ruto's decision will now set a new frontier for Kenyan politics in the next coming days. Martin Opio, K24 TV, Supreme Court, Nairobi.